Good afternoon. Welcome to the William G. McGowan Theater at the National Archives in Washington, D.C. And welcome to those of you watching on our YouTube channel. I'm Tom Nastic, Public Program Producer for the National Archives. Today, our series of noontime lectures continues with James Madison and Constitutional Compromise with our special guest, Sarah Bilder, author of Madison's Hand, Revising the Constitutional Convention. Before we get to today's program, I would like to alert you to a couple of upcoming programs that'll take place in this theater as well as on our YouTube channel. On Tuesday, March 22nd at noon, author and historian Mitchell Yockelson will be here to discuss and sign his new book, 47 Days, How Pershing's Warriors Came of Age to Defeat the German Army in World War I. And then on Thursday, March 24th at 7:30 p.m., we will present the 9th Annual McGowan Forum on Women in Leadership. This year's topic is From the Computer Age to the Digital Age, and will be presented in partnership with the White House Office of Science and Technology Policy. Moderated by Megan Smith, United States Chief Technology Officer. Panelists include Kathy Kleiman, founder of the ENIAC Programmers Project, Tel Whitney, the CEO of the Anita Borg Institute for Women in Technology, Florence Tan, electrical lead engineer for NASA's Mars Science Laboratory, and Emily Reed, Director of Education for Girls Who Code. To find out more about these and all of our public programs, please consult our monthly calendar of events in the theater lobby or visit us online at www.archives.gov. Today's program is the second one we presented in conjunction with our new exhibit, Amending America, which opens today. So if you have time after the lecture and book signing, those of you here in the theater can be one of the first people to see it. But if you don't, you have plenty of time. The exhibit will be on display upstairs in the Lawrence F. O'Brien Gallery through September 4th, 2017. The exhibit is just one of the many nationwide activities the National Archives is presenting in celebration of the 225th anniversary of the Bill of Rights. In fact, our speaker today participated in a fascinating and lively discussion just last evening in this theater on the creation of the Bill of Rights. And if you're interested in seeing that, you can view that on our YouTube channel. Sarah Bilder teaches in the areas of property, trusts, and estates, and American and legal and constitutional history at Boston College Law School. She received her BA in honors and the Dean's Prize from the University of Wisconsin in Madison, her JD from Harvard Law School, and her AM and PhD from Harvard University in the History of American Civilization, American Studies. Her recent work has focused on the history of the Constitution, James Madison and the Founders, the history of judicial review, and colonial and founding era constitutionalism. She's the author of Madison's Hand, Revising the Constitutional Convention, Our Lives, Our Fortunes, and Our Sacred Honor, and the Transatlantic Constitution, Colonial Legal Culture, and the Empire. Following her talk and Q&A, she will be signing copies of her book, Madison's Hand, one level up outside the Archives store. Would you please help me in welcoming Sarah Bilder back to the National Archives.
Well, I'm going to trip on that. Well, thank you all for coming today. I'm delighted to be here and very appreciative to the National Archives for inviting me and to Tom for that generous introduction. I've got a lot of slides, and so hopefully they look good on YouTube. I've never done one where they're filming for YouTube also, so we'll see how it goes. My rule is if you want to write me, I've learned if you show up on things, people write you in the middle of the night, which is when I would probably be watching things on YouTube and C-SPAN too. So I've developed a rule. If you send me your first and last name in your email, I write you back. If you just send me your first name, I won't write you back. But otherwise, I've been trying to write people back. Somehow, a lot of people in South America seem to watch C-SPAN 2 in the middle of the night. And so for my large following in South America, I say hello. I grew up in Madison, Wisconsin, and I sometimes wonder if that's how unconsciously I was led towards thinking about James Madison and the Constitutional Convention. When I was a little girl growing up in Madison, I never thought about why Madison was named Madison. And the entire practice of naming cities after presidents has faded. Presidents are likely and lucky to end up as airports, as people know. Madison was likely named after Dolly Madison, as much as it was named for James. A young lawyer, James Doty, drew up the plans for the city. He had canoed 4,200 miles through the upper Great Lakes, Mississippi, Fox, and Wisconsin rivers, and he learned Sioux, Winnebago, and Chippewa along the way. And for years, he argued that the proper spelling of Wisconsin was with a K. You can see that on the bottom of the screen. Wisconsin, that's not how we spell it today. In 1836, Doty laid out the plan for Madison, and Doty knew Dolly, as he put it, very well. We don't know what that means. The plans dated July 1st, 1836, and Madison had just died. Doty may not have known it. Doty might have assumed that James Madison would miraculously live until July 4th, 1836. July 4th was the date on which Adams and Jefferson had both died miraculously and mysteriously in 1826, precisely 50 years after the Declaration of Independence was signed, as well as James Monroe also dying on July 4th in 1831. Madison, however, refused to take, the letter says, the necessary stimulants, probably opium in the form of laudanum, to keep himself alive, and he died on June 28th. And so you can see, for people wanting James Madison to live 6 more days, and we would have had this miracle. In Doty's plan for Madison, the radial design of streets moves out from the capital, a la this city, Washington, D.C., and they're all named after signers of the Constitution. So growing up with the signers, albeit as street names, has proven useful in teaching and studying the Constitution. I know that Patterson, the delegate from New Jersey who tried to protect equal state suffrage, spelled his name with only one T, and that Jennifer, a little-known delegate from Maryland, spelled his name with only one N. But there's a larger problem. The names that are important in Madison, Wisconsin, turn out to be irrelevant or troubling names with respect to the convention itself. Take Mifflin, where the Mifflin Street Block Party in Madison, Wisconsin was held during the Vietnam War in 1969, and I was a young girl at that point. Thomas Mifflin was actually the Pennsylvania delegate to the convention. I don't think he appears once in Madison's notes, but the street's terribly important. And Langdon Street and its neighbor Gilman Street, which loom large among University of Wisconsin students, they're the big party streets. They were actually named after the 2 New Hampshire delegates who arrived late at the convention, having had to pay their own way from New Hampshire. And one of the most important streets in Madison, Pinckney Street, was named after one of the 2 Pinckneys whose central purpose at the convention was to ensure that Southern slave interests were protected. So my sense of the names bears relatively little resemblance to the standard story of the convention. And maybe in some way this disjunction has helped me think about the framers and the convention in new ways. So my book, Madison's Hand, Revising the Constitutional Convention, explores the distance between Madison's notes and the actual convention. His notes are the most prominent source for the Philadelphia Convention, and they're labeled a top treasure by the Library of Congress, and you can see that right there, and you can see its top treasure number, and the library won't allow me to tell anybody what number that is. I know, but they're like, you can't tell anyone. Okay, so I think they're worried about this. I personally wouldn't, this would not be the top item I would think of taking, but the book itself is a biography of the notes, and I argue that they don't date in their entirety to the summer of 1787, that they were not taken for us, but as a working legislative diary for Madison, and more importantly, Thomas Jefferson, who was in Paris, and that they were revised by Madison as he changed his understanding of the convention, the Constitution, and his own role. And the types of revisions the book talks about include visible revisions, like you can see here on a page. This is the first page of the notes, as well as additional slips like this, as well as arguing that the last part from late August to September was actually composed in 1789. But today I'm not going to tell you the story of the book. You can buy it, and then I can take my kids out for pizza on the royalties, which is about what I get on it. In honor of the new exhibit, I'm going to focus on Madison's relationship to the amendments. Madison's original notes, in the form I argue they existed in the summer of 1787, tell a story of Madison's deepest aspirations and commitments for the convention. And so I'm going to focus on James Madison and 3 compromises made at the convention that wrote the Constitution. But first, some background about Madison and the convention. James Madison looms large in our stories of the constitutional founding. In the summer of 1787, a Constitution was written. But what do we have left of that convention? We have an engrossed Constitution, a building, a Chippendale chair, the inkstand that was used to sign it, and quite a bit of paper, of which this institution holds quite a lot. Thomas Jefferson famously said the Constitutional Convention was an assembly of demigods. Jefferson liked puns, so I've always wondered whether it might not have been a sort of pun on another favorite word he loved, which was demagogue, which sounds an awful lot like demigods. They can be hard to identify with if we want to understand what happened that summer. So George Washington is completely beyond, I think, our reach. Very few of us were ever commander-in-chief of our country's armies at 43. And I think it's equally hard to imagine oneself as Ben Franklin with his Renaissance interest and talent for one-liners, although I think Steve Jobs did because he picked Walter Isaacson, who had written the Franklin biography, to write his own. So that tells you something of Jobs' perception. 2 of the most famous Americans were not at the convention. John Adams was in London, and Thomas Jefferson was in Paris, where he looked somewhat like this, not what we always think of as Jefferson. Both had no idea that they were missing out on the most important event in their lifetimes, and in many respects, the mess they made of the country in the 1790s probably had to do with their own insecurities from having been absent. And other important players are either too exciting, right? Hamilton, who now has his own show, never mind being killed in a duel by a vice president. James Wilson, who is always configured very boringly. He's always shown wearing little glasses like my own, or tainted by their connections to slavery. Charles Pinckney, and this is an image you see all over the place on the web. This is a slave sale from Ashley Ferry, South Carolina in the 1780s, contemporaneous with when the Pinckneys were importing people into South Carolina. So not surprisingly, perhaps, people stumble upon James Madison, and they think of him in some ways that they can relate to him. He was short. He had an 18th century comb-over. He only wore black suits. He was reportedly unlucky as a young man in romance, and then married late in life the irrepressible Dolly Madison, who, as far as I can tell, is the only presidential spouse to be shown with such considerable cleavage on US coinage, okay? And so you have images there, so you can, it's not just I'm not saying that. At various times in his life, he was for states' rights against the national government, for national rights against the state government, for majority rights against the minority, and for minority rights against the majority. He wrote many of the Federalist Papers, is singularly responsible for the Bill of Rights, was a 2-term president. In the 1836 eulogy, John Quincy Adams praised him as the father of the Constitution. But it was his note-taking for which he has been most famous. Now, Madison wasn't the only note-taker at the convention, but he left the only seemingly complete set of notes. And he outlived every other member. This actually wasn't surprising. His mother lived to be 97, and she died in 1829, long after Madison had retired from the presidency, and actually only a few years before Madison's own death in 1836. And as the framers died, Madison actually kept track of their deaths. And so when everyone was gone, he got the last word, what the historian Drew McCoy has nicely termed last of the fathers. And over 600 books and innumerable articles have been written on the convention, and almost everyone has relied on Madison's notes. And so because of Madison's notes, because he was the only one who recorded what happened that summer, and because he was the consummate American politician, Madison is at the center of the three crucial compromises of the framing period. And I'm going to talk about these three compromises and their relationship to this wonderful new exhibit. In American political culture, we often talk about compromise as it is in of itself an important value. We seem to believe that American politics should always proceed by inevitable compromise, even if it encourages and gives voice to ever extreme political positions. And to a significant degree, I think, this rhetoric about the value of compromise as a national good comes from the story we tell about the founding. The conventional story about the creation of the Constitution recounts how the delegates made three brilliant compromises. In the conventional story, the first was over federalism, over there. Without the compromise over representation embodied in the Senate, the small states, so the story goes, would have left the convention. The second was over slavery. The story tells how without the compromise over slavery embodied in the 3/5 clause and other provisions, the southern states would have left the convention. And the third was over rights. Without adding the Bill of Rights to the Constitution, the story goes, the opponents of the Constitution would have refused to ratify the Constitution. In short, the conventional wisdom holds that the Constitution would not have been possible but for these three compromises. Now, don't get me wrong. I find compromise inherently attractive, no doubt because I grew up as one of 4 siblings. We're 5 years apart, top to bottom. I still feel sorry for my mother, okay? I think we, though, sometimes overvalue compromise as a political end in and of itself, instead of being willing to engage in a national debate about good and bad compromises. And similarly, I believe we often see compromises as inevitable because of amorphous political forces. Instead, individuals play critical roles in creating and shaping compromises. So let me explain how Madison's original notes reveal a different lesson about these three compromises, that there are good and bad compromises, and that compromise has as much to do with individuals as with inevitable forces. And so I'm going to focus on James Madison. Let me begin with the compromise over federalism. More precisely, the compromise that results in the division of voting power in Congress, such that the House represents the US population and the Senate represents the states. And this compromise is at the heart of every narrative of the Constitutional Convention. It even bears the name, the Great Compromise, often called the Connecticut Compromise. See, and these are all ripped off the web, so this is the standard story. To understand this compromise, it helps to realize that the Constitution of 1787, our Constitution, was really the second Constitution. The first Constitution was the Articles of Confederation, written by the same Congress that wrote the Declaration of Independence. Under the Articles, there was only one branch of government, Congress. And in Congress, there was only one House. And in Congress, each state had one vote. 9 states were required to agree on most matters. All 13 states required to amend. Basically, a few states could prevent anything from being accomplished, and they did. One state, importantly Virginia, could prevent any amendment to make the system work, and it did. And by the mid-1780s, the Articles were a complete and utter failure. For James Madison and others, including George Washington, a new constitution needed to wrestle power away from the state legislatures. Madison and others proposed a draft of a national government in which votes in both houses of Congress would be based on proportional representation. National government would then be about individuals, not the state or state legislatures, and by this they aimed to fix the central problem with the Articles. As Madison and other advocates pushed this plan forward in June of 1787, delegates of small states saw a problem. I think historians and constitutional law folks misunderstand the nature of the small states problem. It wasn't about an essential idea of state sovereignty as the basis for American politics. Many of them also wanted a powerful national government. But they were concerned about the practical issue of political power. They argued that proportional representation would place control in the large states alone, and there were 3 large states: Virginia, Massachusetts, and Pennsylvania. Virginia was by far the largest. On any issue on which Virginians would see their interests in common with other large states, the individuals who lived in the other 10 smaller states would be repeatedly outvoted. Virginia was the problem. More than any other commitment, James Madison wanted to block equal state suffrage. In a comment that he later struck from his notes, he wrote he was fixed in opposition to such suffrage, and he was prepared for any want that might follow from ending the state suffrage in Congress. Now, this obsession was in part personal. He hated the Virginia legislature. When he had served, and that's the Virginia legislature up there, when he'd served as a state legislator, the Lees and Patrick Henry had blocked legislation Madison had championed, and when he had served in Congress, they had refused to cooperate. And so for Madison, proportional representation promised freedom from his state, from the Virginia political powers he despised. But what he fundamentally could not see was that for everyone else at the convention, Virginians were all first Virginians, and only in some likely, largely irrelevant manner, individuals on any issue with regional implications: slavery, the location of the capital, treaties about the Mississippi, national taxes based on land value or commerce. Proportional representation guaranteed Virginian dominance regardless of whether it was Madison or Patrick Henry who ended up showing up in Congress. So from the end of May to July 17th, 16th, 1787, the convention argued and argued and argued and argued and argued and argued and argued over this issue. On one side stood advocates of proportional representation in both houses. On the other stood advocates for one branch continuing to represent equal state suffrage. They debated other aspects of the national government, but open any page of the notes, and you will find the only real issue fundamentally at dispute was whether the state legislatures would continue to play a role in the future United States government, or whether the largest 3 states could dominate national government. And you'll notice, just let me point this out, Virginia doesn't look like we think it was, right? Here's Virginia, and at that time it includes Kentucky, which they know is going to go on, and of course also West Virginia, which split at the time of the Civil War. And here's Virginia on the population. This is the 1790 census, and you can see this is the Virginia population if you include all enslaved persons. This is the Virginia free population. So they far outstrip every other state. On July 16th, almost 2 months after they were first convened, the convention finally voted for the report and configuration that creates our modern Congress. Proportional representation would govern the House, equal state suffrage would govern the Senate. And even then, Madison refused to accept this compromise. In his notes, he records that the very next morning, before the convention began, members of large states met to consult over what should be done. But nothing was done. Madison complains, the time was wasted in vague conversations without any specific proposition or agreement. To Madison's frustration, proportional representation in both houses was finally dead, and the convention went on to address all the remaining aspects of the Constitution, including rather quickly to try and figure out how to create a president, how to get him elected, what his powers were going to do, everything like that. Now, this compromise was no small compromise. It cannot be altered by amendment. It's one of two provisions in the Constitution that is unamendable. No state without its consent can be deprived of equal suffrage in the Senate. Today, it is the only remaining unamendable provision in the Constitution, although the 17th Amendment in 1913 alters the way it works somewhat. Now, I think this was a good compromise, not because I believe that any compromise that pacified the small states would have been a good compromise, nor because I believe in state sovereignty. I don't, and I think the framers were much more comfortable with the states in a subordinate capacity than we often imagine. But because I believe this compromise recognized a fatal flaw with proportional representation in a large nation. We are a nation that is properly committed to proportional representation as one person, one vote. But we're also an enormously large nation in terms of geography. And the framers were conscious of the growing size of the nation, of a challenge facing a country where people would be unevenly distributed. The curious problem with one person, one vote is that it inadvertently gives political power to more concentrated populations. It favors cities and large states. It did so in 1787, and it does so today. The same anxiety that the small state delegates feared remains true. Proportional representation unwittingly favors a fictional aggregate identity of a group of people, whether that be a state or a city. So a few statistics show this reality. The 8 million people of New York City actually are equivalent to the 12th largest state, behind New Jersey and, ironically, just ahead of Virginia. The 3.7 million people in Los Angeles rank 28th in terms of size compared to the states just in front of Connecticut, with more potential political power than almost half the states. And conversely, the slightly over 500,000 people in Wyoming have as much political power in a proportional representation system as a city ranked number 32 between Oklahoma City and Albuquerque. The 38 million people in California can outvote the people in the 21 smallest states. Now, equal state suffrage is an imperfect corrective, to be sure. And this is a wonderful imaginative exercise in which the states are reconceptualized based on equal populations. But what the Great Compromise ensures, and I think this is why it is great, is that the desire of Americans to live in cities and farms, in crowded places and wide open spaces remains part of our national politics. That large states and large cities don't completely control American politics. And in this sense, I think it's good that Madison failed and that his failure is unamendable. Now, the second compromise linked to the convention is the 1787 Constitution's protection for slavery and acceptance of states that legally permitted people to own people. This compromise eventually brought about the Civil War. And although the 13th Amendment ended the Constitution's legal recognition of slavery, today this nation continues to struggle with the legacy of the constitutional compromise over race. And this is one of my favorite images ever taken of the president when he was on the Rosa Parks bus. And I think it's just a wonderful image of the president. The 1787 Constitution protected slavery. It did so without ever using the word slave. It uses euphemisms, persons held to service escaping, all other persons than free persons, the importation of persons. In 5 places in the 1787 Constitution, slavery was protected. 2 provisions related to representation in the House. These contain the 3/5 clause, the decision that representation would be determined by counting individuals, every free person counting as 1 person, every enslaved person counting as 3/5 of a person. 2 provisions related to the Constitution's acceptance of the international slave trade into the United States. 1 provision stated that Congress could not ban the slave trade until after 1808. The other made that provision unamendable. And the 5th provision gave constitutional protection to individuals who claimed that an enslaved person had escaped into another state. This fugitive slave clause and the laws passed under it would, more than any other constitutional provision, bring about the Civil War. Now, even when I was in graduate school, the conventional wisdom remained that the founders had not really thought that much about slavery. And over the last 2 decades, numerous books have disproved this claim. In fact, Madison's notes make it apparent that slavery permeated the convention. The focus on the future of slavery at the convention is not surprising. Looking to the north, the new nation seemed to be rapidly moving to abolish slavery. In 1787, Massachusetts and New Hampshire abolished slavery based on their new state constitutions and the provisions that all men were free and equal. And the case in which Massachusetts does that is a case called Quock Walker, and those are the notes of the judge in Quock Walker. Pennsylvania, Connecticut, Rhode Island had adopted gradual abolition plans by which people born into slavery would be freed when they turned 28. New York and New Jersey were considering similar legislation. And even as far south as Virginia, efforts to end slavery were being considered. The state had banned the slave trade, although critics pointed out that the gesture had little to do with altering the future of slavery. The vast majority of people held in slavery had been born in the United States. Nonetheless, Virginia political leaders were acutely aware of how hypocritical their claims of liberty equality were, and a faltering tobacco economy made some of them move hesitatingly towards trying to imagine their world without enslaved people. But south of Virginia, abolition seemed a threat to growing states' economies. South Carolina leaders perceived the continuation of slavery as necessary for the state's rice and indigo economies, and Georgia and North Carolina openly permitted the international slave trade. For African Americans living as the property of a white person, the regional divide was the one that mattered. 90% of people held as property lived south of Delaware. Now stop for a moment and count. There were 12 states at the convention. Rhode Island never showed up. Unlike the first compromise I've talked about, where 9 or 10 small states pushed 3 states to compromise, here, according to the traditional story, 3 states pushed 9 or 10 states to compromise the rights and future of enslaved people. Now, why? In part, of course, the protections for slavery occurred because every delegate knew they would personally never be a slave. What slavery involved to them was whether or not they lived in a state that permitted other people to own people or for themselves to own people. They could not be owned themselves. But that doesn't explain how the convention came to persuade itself that it had to placate the states and compromise on slavery. And here, I believe we should place significant responsibility in the hands of one man, James Madison. James Madison introduced the idea of a compromise over slavery at the convention to try and win proportional representation in both branches. Madison thought he could keep together a coalition favoring proportional representation that included Massachusetts and Pennsylvania, large states, and South Carolina, a small state that had slavery. Initially at the convention, he tried to avoid slavery being discussed in order to hold this coalition together. But by the end of June, as he desperately tried to prevent equal state suffrage, he proposed constitutionalizing the difference over slavery, the regional difference over slavery. He explains in his notes, he, speaking about himself, was so strongly impressed with this important truth, and the truth he's talking about is that there is a regional divide over slavery, that he had thought of any expedient that would answer the purpose. And the plan he proposed was to give, as he called it, the southern scale, the advantage in one house, and the northern in the other. And what he planned was that one branch would represent free inhabitants. The second branch would represent all inhabitants, as he wrote, counting the slaves as free. Counting them as free was, of course, a fiction designed to increase the political power of southern slaveholding states. It ignored the reality that enslaved people were denied all rights in those states, never mind being permitted to vote. And you can see by the chart who that would have given power to, right? I mean, you can see how that plays into this Virginia power game. Madison hoped that self-interest and the allure of ever-increasing political power, indeed more political power, for every person held as a slave would lead the three southern states to join the three large states to finally end state suffrage. Madison guessed completely wrong. Equal state suffrage in the end won, but Madison's willingness to constitutionalize the power of the slave states and his implicit suggestion to them, and then explicit suggestion to them, that the slave states needed to ensure that the Constitution would protect their interests, altered the convention. The 3/5 clause, which had been rejected earlier by the convention, was adopted, and from mid-July onward, South Carolina, North Carolina, and Georgia made additional threats and deals as a new voting bloc to ensure that slavery would be protected. This second compromise was a bad compromise. It was not inevitable. To be sure, the Constitution would not have abolished slavery. But I believe that the multiple protections for slavery were not foreordained. Madison was so obsessed with winning proportional representation in both branches in Congress that he was willing to sacrifice the future of nearly 750,000 people held as property, about 20% of the population of the United States. Had he accepted state representation in the Senate at the outset in early June, the political dynamic which produced the 3/5 clause might never have occurred. And without the 3/5 clause and the rise of the Southern slave power in national politics, our entire national history would be different. In the 1790s, the slave states gained 10 or 11 extra seats because of this compromise. In the 1830s, they had 24 additional seats because of this compromise. 5 of our first 7 presidents owned people. Madison made a difference here. He was personally ambivalent about slavery. He did not like slavery. He understood that slavery violated every idea of freedom and liberty, but he accepted and repeated ideas about racial inferiority. He could not imagine a multiracial society. Later in his life, he would become a leader in the effort to remove African Americans to Liberia, and the profits actually from the sale of the notes of the convention were supposed to go to the American Colonization Society. Unlike Washington, or even Jefferson, Madison at his death freed no person that he held as a slave. His former secretary was so horrified by this fact that he wrote inquiring whether Madison's will could be forged. It was not. Madison could not imagine a nation without slavery. And then Madison made this compromise even worse. After the convention, as national fights over slavery grew stronger, Madison became committed to telling a story about the convention in which there had been seemingly no choice on slavery. He obscured his own role by insisting that the southern states would otherwise have left the convention. And you can see that this is an abolitionist tract, pro-slavery compact, and that's where the whole myth becomes part of the abolitionist anti-slavery and pro-slavery debates in the 19th century. Over time, Madison's claim about inevitable compromise over slavery became part of a national belief that the Constitution required compromises over slavery. And in Supreme Court cases like Dred Scott, and this is the famous portrait of Dred Scott, and federal legislation and practices like the Missouri Compromise, this commitment to a fictional compromise eventually led to almost 4 million people, 90% of African Americans in the United States, being held in slavery. A history that only began to be resolved with the Civil War and the 13th Amendment and the 14th Amendment and the 15th Amendment and the 24th Amendment and continues today. Now, if Madison stood in the way of the first compromise and can be blamed in large part for the second, he actually deserves credit for the third. The third compromise is the decision to add amendments relating to rights to the Constitution. And ironically, because Madison deserves so much praise, the story can be much shorter. So don't worry if you're watching your clocks, okay? When the Constitution was completed on September 17, 1787, it included no Bill of Rights. There was no Bill of Rights in any draft presented to the convention. The idea was eventually formally proposed, but not until September 12, 1787. And at that point, the convention was putting final touches on the final draft of the Constitution, so they, to appoint a committee, the convention ends on the 17th, which is Monday after a weekend. So this is pretty late in the day. Quite frankly, the suggestion for a committee to write a Bill of Rights was likely intended as a disruptive delaying tactic, and the motion was rejected 0-10. We don't know anything more because Madison's notes for these final weeks were composed 2 weeks after the convention, after he had actually written the amendments. Now, the conventional story, indeed the one I used to teach, was that the Bill of Rights was added to the Constitution because opponents of the Constitution could not otherwise ratify it. But recent work by Jack Rakoff, Pauline Maier, Bernard Balin, and others has shown that without James Madison, amendments about rights would never have been added to the Constitution. When the Constitution was sent to the states for ratification, the absence of a Bill of Rights did not initially bother everyone. 6 states did not have bills of rights in their own state constitutions. And across the states, only 2 rights appeared in a majority of constitutions. The vast majority included a jury trial in criminal cases, and most had some recognition of religious liberty stated in various ways. But gradually, the absence of a Bill of Rights became a debating point in the ratification conventions, and it proved a particularly annoying problem for the Constitution's defenders. At first, they tried to argue that the government was enumerated and could not violate anyone's rights. Because the national government only had the powers granted to it, rights didn't need national protection. But the problem with this argument was the drafters had not believed it themselves. In fact, the Constitution contains rights. Indeed, it contains some of the most important rights. Article 3 ensured that there would be a right to trial by jury in criminal cases. And this was long part of Magna Carta and the right most often included in state constitutions. Important limits on the power of legislature against individuals was established by provisions that barred the suspension of habeas corpus, bills of attainder, and ex post facto laws. Article 4 guaranteed a bar on monarchical governments and all of the things that went along with them in the republican form of government promised to most states. And perhaps most dramatically, Article 6 barred religious tests for office and, importantly, guaranteed the right to affirm instead of swear when taking office. Jews, Catholics, deists, and others were under religious disabilities in various states, and the Constitution in this regard represented a dramatic divergence in ensuring a national government of office holders who could take without regard to religious belief. These rights in the Constitution implied that the government might indeed threaten rights through the expansive powers given to the national government. Nonetheless, the absence of a Bill of Rights was actually not the most common complaint about the Constitution. Pauline Maier points out that the number one complaint was basically taxing provisions, and that was far greater than any concern over rights, probably be true today. Once the Constitution was ratified, no one really cared about rights. The state ratifying conventions had sent in amendments, but they were recommendatory. By June of 1788, 9 states had ratified, and the Constitution was in effect. The ratification by Virginia and New York in late June and July sealed the deal. 2 states were pokey, but they faced the threat of being excluded and eventually came around. Even recalcitrant Rhode Island finally ratified in May of 1790. And in the new Congress, in the spring of 1789, other business seemed far more pressing than amending the Constitution. What should they call the president? His Excellency? And watching, everybody in their fancy dresses yesterday, I was thinking, you can see why people worried about would we get the right respect. The no longer slim John Adams wanted His Most Benign Highness as the title for the president, and for that suggestion, no more popular then than it would be today, he became called behind his back His Rotundity. At this moment, when compromise was no longer necessary at all, James Madison plays his crucial role. When the new government was forming, Madison had run for the Senate in Virginia, and he had lost. And he then ran for the House seat, but his district had been redrawn to favor Monroe. And opponents told people that Madison was against the rights of the people. So Madison scurried back to Virginia, and he campaigned, which meant he wrote some letters to people and to a couple newspapers. And he said he was for all essential rights, and he won. And then he went on to fulfill his campaign promise. In Congress, he drafted and proposed amendments to be added to the Constitution. He worried people would think that the list didn't include all rights. And so he added what we know of as the 9th Amendment. His original planned amendments were radically different from those with which we are familiar. First, he thought the amendments should be interwoven into the Constitution. But Roger Sherman said, let's add them to the end. And secondly, he included amendments that did not relate to rights. In fact, when the amendments were sent to the states for ratification, there were 12 of them. And this is the original 12. The first 2 related to the ratio of representation and congressional compensation. Our first amendment was actually originally number 3. Only because of the fortuity that 2 amendments failed to be ratified in 1791 did the First Amendment end up being first. And for trivia experts, the original Second Amendment on compensation was ratified in 1992 when it became the 27th Amendment. Madison believed that rights were important, and his arguments to Congress on June 8, 1789 remain true today. He admitted that people had often considered rights as paper barriers and that they were next to worthless sometimes. But he predicted that in the new government, independent tribunals of justice will consider themselves in a peculiar manner the guardians of rights, and they will be an impenetrable bulwark against power. And even more importantly, he began to believe that the people would believe in rights. If the rights impressed some degree of respect, he said, they would establish the public opinion and control the majority from those acts with which they might otherwise be inclined. Without Madison, I believe we would have no Bill of Rights in our Constitution. Now, 225 years later, the compromise about equal state suffrage is useful, but we don't think about it very much. The compromise over slavery has fortunately been abolished, but we continue to wrestle with its terrible legacy. For us in the 21st century, it's the third compromise that matters. Constitutional rights have become part of our national culture. We have bills of rights for patients in hospitals, for subway riders, for airplane passengers, for pets, most of them on crinkly-looking yellow paper with computer-generated water stains. I even have this placemat from Burger King with the advertising slogan, "You have the right to hold the pickles and hold the lettuce." Madison might be turning in his grave, or maybe not. In the end, in the long arc of history, individuals matter. And compromises may on occasion be good or they may be bad, but they're rarely inevitable. In working to amend the Constitution, Madison, in the end, ensured that the Constitution itself could be changed. Thank you very much. I'm delighted to have joined you here at the opening of this wonderful exhibit. So I think I'm supposed to say, if you want to ask, I think we have some time for questions, you're supposed to go to the mic so that you can also be on the YouTube video. Yes, sir?
Hi, I'm David Belducci. I'd like to follow up on something you didn't get to last night. Two of your colleagues indicated that there seemed to be a collective militia right around the second, what we now know as the Second Amendment. And another of your colleagues said that there was distinctively an individual right, and there was a disagreement, and you didn't have time to voice your view on that related to the Heller case, and I wonder if you'd share that with us.
Yeah, I was sort of hoping no one would notice I didn't have a view on that. I happen to be a person who, I think, like many people who do constitutional history, see the origins of the Second Amendment in the concern with militia, and that when people used the phrase bear arms at that time, they meant have weapons for the purpose of serving in the militia. And I think that when you read, there's just an enormous amount of places where those words come from. And so I think that I probably end up closer on that side. How it plays out in the 21st century, I don't happen to think the Supreme Court should follow tooth and nail what everybody said in 1787. So I think one could come up with a different way to find a modern individual right. But I think it's very hard to argue that they, in 1787, saw it the way we see it. And I think part of that story is that that the whole story of the militia is something that we don't follow any longer. Yes, sir?
Yes, thank you. Excellent talk. I was wondering if you could talk about why there wasn't a protocol in that time to have an official note taker who was neutral rather than being one of the participants.
Yeah, excellent question. There actually was a person, there was a secretary for the convention, and the secretary's notes, the archives actually has them. You can, they've got a few of them, I think, digitized. You can see most of them on, I don't know what, Fold 3 or whatever that's become. Anyway, you can see the official journal of the convention. Let me step back. We assume legislatures are supposed to be open. At the time the Constitution was written, the opposite notion was in place, that the legislature was supposed to be closed, and what the public had the right to was the official journal and sort of the consequences of the discussion, much like the way we think still of the Supreme Court, where we don't get to see their deliberations, we get the opinion. And this was more pervasive than we realize. In the new Congress, the House opened to the public with galleries, but the Senate remained closed into the 1790s. And only under public pressure did the Senate finally admit, okay, this is a new era, we need to let the public in. So there was an official record. William Jackson did take notes, but and then at the end of the convention, he burned all the extra paper, and what he kept was the official journal, basically the official record. And in the Washington administration, this story is in the book because my book talks about the manipulations of the record with respect to Madison and Jefferson. Washington gets very upset that Madison and Jefferson have begun to argue things that he believes are counter to the Constitution's record of the convention. And so he's in possession of the journal, and he goes down and deposits it in the basically Department of State. And they record it, deposit it and everything, and then he goes and gives a big speech on the Jay Treaty and says, you can see the convention journal. And Madison freaks out, like, what? What's going on here? But it's too late, because now the convention journal is part of the public record. So that story is very important, and I love that story, and it's in my book in much more detail.
In other words, you don't know the answer. Thank you.
You mean why they didn't have?
I'm kidding.
Oh,
That's
okay,
very good.
sorry.
Thank you.
Yes, sir.
I have a couple of questions. First of all, Madison revised his notes after having taken them at the convention, and I'm wondering if there's any possibility that in revising those notes, he was thinking that they might be used at some point and he wanted to basically change history. And my second question is whether it's possible that in pushing for proportional representation at the expense of provisions that protected slavery, he was thinking that what actually happened would happen, which is to say that we got rid of slavery much, much earlier than we got rid of equal Senate representation in the equal state representation in the Senate.
Yeah, two good questions. The first one, I happen to believe that in the late 1790s, Jefferson pushed Madison to publish his notes. Jefferson thought they would be useful in his push towards a Republican government. And I think he thought that they would prove to people that there had been secret monarchists like Hamilton at the convention. And Jefferson actually makes his own copy of the notes, of Madison's notes. Madison declines that and tells Jefferson, there's actually a very funny statement, this is also in my book, where Madison sort of says, you really ought to look at every page, because he was always suspicious that Jefferson hadn't looked at everything. And he also gets worried that other notes will come out. And so Madison's notes and his revisions at some part are, I argue in the book, for some of them are part of a plan with Jefferson towards Republican government, and that Madison basically gets cold feet and they back away from it, and then eventually he decides to do them posthumously. I think I'm tougher on Madison than probably your question. I really think Madison has been given a pass on the slavery issue. In the 1790 Congress, this is very nicely written about in Joe Ellis's book, Founding Brothers, among other places. Madison works very hard behind the scenes to make sure that the petitions to abolish slavery are sunk, and that there's committee report that basically says the Constitution doesn't have the ability to end slavery. And so Madison wanted the United States out of the international slave trade. Lots of people did, but that had nothing to do with slavery. I mean, it's an interesting question, and I don't know what the answer would be about how Madison would have felt about what becomes the 17th Amendment. My own guess is he would have liked it, because he would have loved to have stood the chance of being a senator without having to been elected by the Virginia state legislature, which was never going to elect him. So, so personally, if he had thought of the 17th Amendment and thought he could have gotten it through that way, he probably would have been for it. Yes?
Terrific talk, thank you. My question is about Thomas Jefferson's role, if any, in the development of the Bill of Rights. I've read interpretations that it was really Jefferson writing to Madison who kind of twisted his arm and really talked him into it, that it was something that Madison didn't really think was necessary, and Jefferson said you really, really ought to have a Bill of Rights, and that it was Jefferson who kind of talked him into it. And what's your take on that?
Yeah, so, and this was actually on the panel last night, we talked a little bit about this. You know, my own sense is that Madison is already moving on his own towards favoring amendments. He wanted to, he wanted ratification to be sort of cleaned up and over. I think he thought if he wrote them, he'd be in control of them, so there weren't going to be any problems. He took it as an opportunity to amend the Constitution in other ways. I personally believe that this very famous exchange of letters that he has with Jefferson are useful in him thinking through what the arguments would be to support favoring that. And the two that I give here, Jefferson also very much agreed that the judiciary, the new judiciary, would be important in a Bill of Rights, and that in that sense that rights wouldn't just be something nice like the Declaration of Independence, but that judges could actually use them in specific cases. And so I think their relationship was very important in that. In fact, there's a very funny moment in ratification where Madison, in the ratification process, where Jefferson's written Madison, you know, hey, I like the Constitution, but you guys screwed up a bunch of things, and one of them is there's no Bill of Rights, but, you know, whatever. And Madison goes and tells people, you know, a friend of mine, so everybody knows that's Jefferson in the Virginia Ratifying Convention, is favorable towards the Constitution. And that's leaving out the fact that he knew perfectly well that Jefferson had written him, but it was a big mess up not having a Bill of Rights. So he manipulated that relationship himself. Yes, sir?
Another religion question from last night. When I started at the Census Bureau, we had to take an oath. And the oath included, so help me God. And when we had our legal update later, the guy said, well, you know, you don't have to say that, but technically you can be fired because you didn't actually take the oath, and the oath is prescribed in federal law. How does that fit into the fact?
So you actually, I mean, I don't know the practices of any particular government agency, but you actually are allowed to affirm. It's just very few people affirm.
But I have so help me God.
Right, but you actually don't have, you can say ahead of time that you're going to affirm. So just as a matter of things, for years and years, I've always affirmed because of my own private religious beliefs. And so whenever I take oaths, I was a federal employee as a judge, and then recently I got sworn into another bar. And I always say ahead of time, I don't take oaths because of my religious positions, and so I would prefer to affirm. And they're always like, oh yeah, okay, you know, don't worry. And then they're like, blah, 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 so help me God. And then the last time I did this, the person's like, oh, wait, no, whoa, no, let's do it all over again. And I was like, well, I'll just not say that part, you know? But I was like, it's not a big, it's just my own thing. So I think you could look this up on Wikipedia. I think there's 1 or 2 presidents who affirmed, no one in the recent position. I think Pierce may have affirmed. But you can imagine, you can imagine now, talk about a radical thing in American politics, to stand up and affirm, which the Constitution gives you the right to say, that because many religions don't believe you should say, so help me God out loud when you're saying, and the anxiety about oaths was deep at the time of the convention. So yeah. So in theory, and this is a small thing. If you cared about like fulfilling the Constitution, you could go around and insist on affirming in your few chances of taking oaths. On the other hand, you might just want to keep your job. So, yes, sir.
Relative to the 3/5 clause, I believe you put on the screen the fact that that clause pertained not only to representation in Congress, but also to direct taxation.
Right.
Which would obviously be not as beneficial to the South as the part providing representation, and would concomitantly be advantageous to the North. To what extent was the 3/5 Compromise aided by Northern wishes to reduce their taxation?
Yeah, so the history of the 3/5 Compromise, Madison is actually responsible for the 3/5 Compromise. It's it's invented as a part of the revenue measures in the Confederation Congress beforehand. Madison, in his own, he kept notes of his activities in that Congress, and Madison suggested the 3/5 idea as a way of taxing when they were trying to figure out how to tax. If they could imagine how to create a revenue bill, they would do that. And in the beginning of the convention, the 3/5 clause is voted up, it's voted down, and it's finally voted up again. And so it's a very complicated history. And in the beginning of the convention, the two provisions are linked. And what's interesting is in Madison's notes, as the convention goes on, there are people who increasingly say we could abandon the taxing part of the 3/5 clause and simply keep the representation part of the 3/5 clause. And so there's actually efforts to take those two pieces apart. And the 3/5 clause is fascinating, and I think the people who are in some ways most troubling are the people who voted for it from states which were abolishing slavery. And I think one of the most interesting people there is Rufus King, who comes to a decision personally somehow that he has to side with the 3/5 clause. He's close to Madison at that point, but by the end of the convention has begun, along with people like Governor Morris and others, to feel that the slavery issue is far worse than he could have understood, that there's never going to be abolition. And people like King and others leave the convention, and they go on to become anti-slavery advocates. So in some ways, I think more than we understand, this fight over the 3/5 clause almost begins this very important national discussion over slavery.
And we're out of time.
Thank you.
Mary.
Thank you.